Well, welcome everybody to this webinar on the Chinese Personal Information Protection Law. My name is Gary Friedlander. I'm the Interim Director for the Center for Intellectual Property, Information and Privacy Law at the University of Illinois, Chicago. I'd like to welcome our panelists. We'll start with Noah Bledstein. Noah has been practicing in Wisconsin since '94. Graduating from the University of Wisconsin Law School. Prior to law school, he attended UIC, so we have a good alum there. Following law school, he had a direct commission into the Air Force JAG Corps, and he earned an IP LLM from Washington University in St. Louis, and then spent the last 10 years of his career with the Air Force as a cyber law legal advisor position at the National Security Agency. And following retirement from the Air Force, Noah joined General Electric in 2014. And since 2018, he's been the Senior Counsel for Privacy and Data Protection for GE Corporate. Next, we have Sooji Seo. Sooji is Senior Vice President, General Counsel, Information and Digital, and Chief Privacy Officer of 3M Company. She serves as primary General Counsel for the information security, cybersecurity and digital organization, and leads legal support for privacy, cybersecurity, trade secrets, IT, data security, information governance, IT sourcing, and other IT legal matters. Just a few things there. Prior to 3M, Sooji worked for Dell as Dell's Vice President of Ethics and Compliance and Chief Privacy Officer. Sara Susnjar is a multilingual partner of Winston and Strawn, admitted in both Paris and Illinois. She concentrates her primary practice on cross-border complex business transactions with a focus on M&A, joint ventures, and private equity. She has advised and represented some of the biggest tech and media market players. In addition to her experience in other international law firms, Sara has worked for governments and international organizations such as the U.S. Department of Justice, the Robert F. Kennedy Center for Justice and Human Rights, delegation of the European Union to the United States, British Parliament, and the United States Congress. Dr. Annie Xue, is the partner heading up the compliance practice of Zhen Law Firm, a Chinese law firm headquartered in Beijing. She specializes in regulatory affairs and data privacy. She studied competition at the College of Law of the University of Illinois, another alum, and obtained a JSD degree. She has also participated in many research topics led by law enforcement authorities and academia as a postdoctoral fellow at the Institute of Law of the Chinese Academy of Social Sciences, and actively contributed to the formulation of competition and data regulation policies. So as you can see, we have quite the experienced and preeminent panel to talk today about PIPL. Before we get started, I just want to thank our annual sponsors, McAndrews and Leydig, for their support of our ongoing yearly programming. And I also want to thank all of our center institutional partners who you can find within the speaker bios that has been made available online to all the attendees, as well as some other continuing legal education materials. So with that, I'd like to start with Annie. Annie, can you give us an overview of PIPL?
Sure, Gary. So good day, everyone. Thank you, Gary and UIC for having me today. I'm delighted to join the other three very experienced privacy professionals to explore the interesting topics about China's data privacy regime. So first of all, I can give you a very brief overview of the PIPL, Personal Information Protection Law. So actually, China's PIPL was released in August 2021 and became effective almost 3 months later in November of the same year. The legislation goals of this law is threefold: to enhance the protection of personal data. As you may know, that Article 1 of the PIPL says that the law is made in accordance with China's constitutional law. And in China, not many laws directly mark constitutional law as a legal ground. And the second legislation goal is to foster a sound network ecosystem and protection fair competition. And the last, but definitely not the least, is to promote a digital economy and China's competitiveness in the global market. Although China has its own defined goals, definitely the EU's GDPR serve as a role model for China's rulemaking. You may find quite some similarities in terms of basic principles, data processing, legal basis, controller processor regulatory obligations, data subject rights, cross-border data transfer regimes, etc. Actually, Sarah and I is going to address it a bit in a bit more details later on. However, we also have certain differences with, we always call it Chinese characteristics. For example, legitimate interest is not available as a legal basis under PIPL, and there's no one single dedicated data protection authority as a case in the European Union. Instead, China applies a multi-authority approach. And more recently, at the 2 sessions, another one, a very new one, we call it National Bureau of Data, was established, making the landscape a bit more complex. It's also noteworthy that in the field of data privacy and cybersecurity law, there are in total 3 pillar laws, including PIPL. That's a focal point for today. And we also have data security law and cybersecurity law. The data security law, in short, DSL, is a framework law for the governance and regulation of all kinds of data, including personal and non-personal data. And the CSL, cybersecurity law, is chiefly focused on the security of network facilities, devices, and software. The famous, if you something about China's cybersecurity law, the famous multi-level protection scheme, in short, MLPS, and the network security review. The 2 regimes are actually provided for under the cybersecurity law. So Gary, that's a very brief overview of China's data protection regime and the related security regime.
Thank you, Annie.
Yeah.
Annie, Sarah, can you talk a little bit about the most recent events before we get into comparisons and then talk about the implications, particularly for multinationals? I understand that there have been SEC rules and standard contracts. And can you talk a little bit about that, the application scope, the grace periods?
Sure. Sarah, would you like to go first?
Well, in regards to the recent developments in the EU, regulations around the data privacy, they continue to develop at a very, very rapid pace. Emerging technologies have changed the manner in which personal data is collected and used. And in order to kind of briefly summarize it, I've come up with 6 new, I would say, developments in the past year since 2022. The first one is, and the one that we still keep talking about, is the fallout from Schrems 2. The fallout from the Schrems 2 decision, it continues to impact business, especially when it comes down to cross-border data transfers between the EU and the US. A point that that Gary just brought up is there has been the adoption of the new SECs, the new standard contractual clauses. These new clauses have been presented last year, but for companies to start complying with them, the goal is to actually get them in place ASAP. And that's the recommendation, get them in place ASAP. The third thing on the list is that there has been an EU and a US movement to renegotiate an agreement to allow for the free flow of personal data. I think that you're all aware that in October 2022, President Biden signed an executive order outlining specific ways that the US is going to fulfill commitments under the new US-EU data privacy framework. In December, the European Union did the same thing. The European Commission and they submitted a draft decision for review before moving forward with the adoption. The fourth thing on my list is that GDPR fines have ramped up. And the way that we can present that is in 2018, there were 16 fines. By 2022, we had 2.92 billion euros in fines, so hundreds of fines more, only 4 years later. One interesting thing that has happened in the past year is that data breach notifications have been down despite these fines. So authorities are finding ways to fine not just on the basis of a data breach, but on the basis of other reasons found under GDPR. And the last development I would say is that AI questions are on the rise. And I think that's across the board for almost any jurisdiction. So those are my top 6 for 2022.
Yeah.
Thank you, Sara. Go ahead,
sorry.
Annie.
Yeah. Actually, from the China side, I would say more recently, 2 kind of developments that are noteworthy. So first of all is about cross-border data transfer. Yes, in China we also have the Chinese version of standard contractual clause. And we also have the so-called networks security review, conducted and led by the Chinese cyberspace administration, and all that pointed to a very important kind of mechanism provided for in China's PIPL under Article 38. It said that at least one of the 3 main preconditions have to be met, in order to do the cross-border data transfer in a compliant way. One is security review led by the CEC. The second one is certification. The third one is a standard contractual clause. And the fourth one is a catch-all clause. So what's very important is the thresholds to trigger the so-called security review led by the CEC. So basically, there are kind of 4 conditions, or thresholds to trigger the security review. One is that you export important data overseas. Of course, what will constitute important data? That is something that is subject to more clarification of the government, because they are supposed to come up with some catalog in general and maybe in some specific sectors and industries, but they have not do that yet. And secondly, if you or one of your systems fall into the category of so-called critical information infrastructure, you as a business operator will be defined as a CII operator. And if you export personal information overseas, you will do the security review. And if you are not a CII, but somehow you're a data processor processing, at least 1 million individuals' personal data, and you do the cross-border data transfer, you're subject to a security review as well. And the last threshold would be, from January 1st of last year, cumulatively, you have exported 100,000 individuals' personal data, or 10,000 individuals' sensitive personal data, you also need to do the security review. So actually starting from March 1st, the grace period for the preparation work has already expired. And the government agencies really pushing the business operators to make the filing and do the assessment and see whether they have triggered the threshold. And if so, they should go through the review, make the filing. And when it comes to the standard contractual clause, this kind of new rule will become effective on June the 1st. But there is also a 6-month grace period. So you still have some time to make the preparation. So if you do not trigger the security review, it is subject to your option. You can do certification, but you can also do the ICC, Chinese Standard Contractual Clause. So I would say that are the most recent and most important developments for the data privacy in China. Gary?
Annie, you mentioned that there's no single regulator, and you talked about the National Bureau, and we've all heard about CAC. Can you just spend a few minutes describing the different players, how they interact?
Yeah.
You know, what the implications are, you know, for businesses trying to navigate all of these different entities.
Sure. So as I said, in China, we apply a multi kind of authority approach, which means that several government agencies, they may share, you know, the enforcement authorities, but they may have, you know, their specific focuses. So for example, CAC, actually CAC is the abbreviation for Cyberspace Administration of China. You know, before the adoption of the Chinese cybersecurity and data protection laws, this agency was chiefly charged with overseeing online content. So like you should not put online something related to pornography or anything against the Chinese kind of moral standards. So basically that's their job. But after the establishment of the data regulation and the cybersecurity regime, the CAC is responsible for leading and coordinating the rulemaking and law enforcement activities. So apart from the CAC, we also have MIIT, the Ministry for Industry and Information. So if you're, you know, a telecom carrier, or if you provide, you know, value-added telecom services, all the telecom licenses, which is very, you know, relevant to like data privacy and also to cybersecurity. So all the licenses are regulated by this ministry, and this ministry is also responsible and also oversees like the data privacy, data protection in the auto sector and in the field of industrial data, you know, all the data generated in manufacturing and so on. That's MIIT's focus. And we also have a very important player here, which is the Public Security Department and their local branches. So as I said, we have the multi-level protection scheme, MLPS, and actually the Public Security Department is responsible for enforcing this kind of mini scheme, I would say, under the China's cybersecurity law. And it's super important for, you know, providing a corresponding protection level according to the sensitivity of the data. You know, if like the state secret or important data, it may call for a higher level of MLPS protection. Definitely the industry regulators like the People's Bank of China and the regulators overseeing securities, banks, insurance companies, and so on, they also have their own specific dedicated rules to information protection, including personal information and non-personal information. Now with the setup of the National Data Bureau, the industry policy and digital strategy planning role previously assumed by the CAC, they will be transferred to the new agency. So I just checked the website of the NDRC, you know, because the National Data Bureau will be based under China's NDRC, a very powerful departmental agency, which is also called mini state council. At the same time, you know, the official website of the National Data Bureau has not been set up yet. So which means that it has not been fully operationing. So, but we can predict that, in the near future, all the, development and the full functioning of the new bureau can be expected. Yeah, that's all, Gary.
That's all, huh?
Yeah.
Thank you. Let's now talk a little bit about the comparison. GDPR has become the de facto gold standard for all these privacy laws around the world. I mean, there's so many of them, and they all kind of vary from, country to country, but generally, more or less, they're based upon GDPR now. So all companies are running to GDPR, including all of us in the States. So how does GDPR compare with PIPL? About the scope, lawful basis, how personal information is defined. Sara, do you want to start this one? Oh, you're on mute.
Sorry about that. I was saying I'm going to start with the applicable scope, and then I think we'll go item by item between Annie and I, if that works for you. So in regards to the applicable scope, I think I froze for a sec. In regards to the applicable scope, we know that both are extraterritorial, both PIPL and GDPR are extraterritorial. But the question that always gets asked is, well, under GDPR, how does it work for me? I mean, I'm a company, what kind of law is going to be applicable? What national law is applicable? I realize there's a law on the EU level. What authority do I go to? And the question that we always ask is, well, where are you incorporated? Where's the company based? Where's the information getting transferred from and to? And so the question is always, where is the company located? And that's what we typically ask as the very first question. It decides a lot of things for us for the next level of analysis. And that's how the applicable scope is, starts to be analyzed. With PIPL, it's a bit different. Annie, do you want to go into that?
Yeah, PIPL, as I said, actually learned a lot from the GDPR. So basically, of course, it mainly applies to the business operators operating in China, and they process data generated and collected, during their operation within mainland China. But the Chinese personal information protection law also has extraterritorial jurisdiction, which is quite similar to the GDPR. So as long as you process data or collect data, from China, and although you may be located outside of the territory of mainland China, but still you are subject to the jurisdiction of PIPL, and you need to also finish, all the compliance work and efforts. So one quick note is that, Hong Kong, Macau, and Taiwan, PIPL, generally speaking, does not apply to the three jurisdictions. Yeah, that's a quick note.
Okay. The second, I think, area of difference is the definition of personal information. I know Annie will say that the PIPL and GDPR are more similar than different, but I think the definition of personal information, there is a point to discuss that, partially because how PI is defined, I mean, it's the basis, it's the cornerstone of at least GDPR, and in a similar way of PIPL. So when it comes to the definition of personal information, GDPR and PIPL have a similar definition of either direct and indirect, but where the differences come is that GDPR does not explicitly exclude anonymous information from the definition of PI. And I think that to some extent, we're going to see a lot of developments in this area, especially with AI. But I think that the explicit lack of exclusion of anonymous information is going to be a trend, at least in the next couple of years, with GDPR and how we will treat that information and how we'll look at it. A second pretty obvious way that PIPL and GDPR are different is that is the definition of the special category of data under GDPR. As you know, under GDPR, the special category of data is actually much more limited. And what I mean by that, it's typically things like sexual orientation, political beliefs, political knowledge, ethnic or racial data. I mean, that kind of data is considered to be sensitive. Now we call it a special category of personal information, but the scope of that information is actually quite limited. Under PIPL, it's much more, much larger. And Annie, do you want to get into that?
Yeah, sure. Yes, in China, for example, for personal information, actually, we specifically call it personally identifiable information. So that's why I guess that's why probably Sarah said that that's a significant difference between PIPL and the GDPR, because according to our Article 4 of the PIPL, anonymized personal data will not be regarded as PII, personally identifiable information. It's not subject to the PIPL. So for those kind of sensitive personal information, apart from those, Sarah just mentioned, some other like financial information and tracking information, and quite some other kind of personal information may also fall into, we call it sensitive personal information, but basically the same notion, but different scope with a special category of personal information under the GDPR. Yeah.
Okay. The next area is, and I think out of the differences, this is probably the most important one, but it concerns the legal basis for processing personal information, the legal basis for processing the PI. Now, GDPR and PIPL are pretty, they have some similarities in how they define obtaining consent, performing contracts, vital interest, but there are also certain differences. And one of the main ones is that GDPR allows companies to process personal information for the purpose of legitimate interest. And so if there's a legitimate interest to do so, meeting all other GDPR requirements, under GDPR, you're able to do that. Before we get into the other differences in regards to consent, especially maybe the obligation to notify, Annie, do you want to talk about the legitimate interest purpose, which is not included in PIPL?
You mean apart from legitimate interest, or including legitimate interest?
Excuse me, but legitimate interest under GDPR is used as a means to exactly, but under PIPL it's not the same thing.
Yeah, it's not.
It's included, yes.
Yeah. So I think that's a very important difference, because this has presented significant difficulties for many of our clients. For example, our clients want to set up a camera to protect their business properties, but under the Article 13 of the PIPL, probably it's not easy for them to secure the consent, and probably there's no rule or from the collective agreement with employees, and probably even no legal obligation to do that. The single purpose is to protect the business property. But Article 13 of the PIPL does not provide, a kind of sufficient legal basis and convenient legal basis, as in the case of GDPR, to do that. I think that's a very important difference, and a very significant difficulties for the business operators. Yeah.
And you mentioned consent, which is also somewhat a divergent with PIPL and GDPR, because under GDPR, consent to us is golden, right? You get a consent from an individual or data subject, you get a common legal basis for processing personal information. Yeah. It's quite simple. But under PIPL, it's quite a bit different, because there's just not, consent is not seen as just a one yes or a one no or an opt-in or an opt-out. Consent is seen much more, I would say, it's more scrutinized on a higher level.
Yeah, you have to, provide sufficient transparency before you secure the consent, and your processing activities also have to comply with the minimization kind of principles. So only a consent, it does not mean that it's a valid consent. I think in this regard, it's not significantly from the case as a GDPR. And it just come to my mind. I think another very significant difference when it comes to the legal basis is that under the GDPR, you can only choose one or the other, right? In terms of the lawful basis. But in China, we do not have this mandatory requirement, especially nowadays. Many companies does not feel safe if they get the consent because they are not quite sure this consent is valid. So normally they could do multiple things to ensure that they have the sufficient legal basis to do the data processing. Yeah.
Okay. The next one I think that we should talk about are the consequences for non-compliance, the punishment for both companies and individuals and how that works under GDPR, PIPL. We know that there are stringent penalties for violation of data or personal information or failure to protect certain responsibilities. We know that, as we mentioned earlier at the beginning of the session, that nowadays in 2022, there were close to almost 3 billion in fines in Europe, 3 billion euros in fines given out here in the European Union among hundreds of cases, whereas in 2018 there were only 18 cases. So we see a number and a growth in the fines. But the question is really what's the difference? I mean, how does it work under GDPR? How does it work under PIPL? We know that under GDPR, the maximum penalties are 20 million euros or 4% of the company's total global annual turnover, whichever is higher. This means a lot, but it also means nothing. It means that everything is looked at on a case-by-case basis and that to some extent fines can be unlimited. This also means that GDPR imposes penalties only on companies and only on the data controller or the processor that is a company. So we're looking at fines on companies. But under PIPL, we're looking at fines from a whole different spectrum. Do you want to get into that, Annie?
Yeah, sure. Actually, I think the Chinese PIPL draws quite some inspirations, I would say, from the GDPR and also from the Chinese anti-monopoly law. Of course, China's anti-monopoly law also learned a lot from the EU's competition law. So basically, our administrative penalties for the violation of personal information protection rules could be like 50 million RMB or up to like 5% of the previous year's turnover. Like this kind of percentage based penalties is very similar to the Chinese anti-monopoly law, although in that law it's like up to 10% of previous revenue. But I think one thing that is different from between China and the EU is that normally they just use a base of your turnover within gained within the territory of mainland China. But probably in the European Union, you use a global revenue as a base number to calculate the penalties. And another very significant difference is that in China, we also have the individual liability. For example, the senior executives charged with overseeing personal data protection, or the directly responsible personnel could be subject to up to like 10,000 RMB to 1 million RMBs administrative penalties. So that's a big stake to like directors and the senior executives and the privacy protection professionals within the company.
When it comes to fines, what we've seen here in the European Union, obviously the fines are given on a member state level. So it might be the French, data protection authority like the CNIL. It might be the German data protection authority, which is actually, I call it divided into fiefdoms, because their data protection authorities are by each, each section of the country, each fiefdom. And what's ironic is that, to some extent, there's a transparency to the fines, because it's clear as to each data protection authority is very clear about and eloquently stating about why this is the fine, how the amount was calculated, and so on. But to some extent, under GDPR, as a civil law and a common law lawyer, I would say that there's no stare decisis, right? One decision does not necessarily impact the next decision, and one decision might be 700 million, but the next decision under a similar fact pattern might be much less. And so as a common law lawyer, the lack of stare decisis within decisions is obviously, surprising, but as a common law lawyer, I completely understand it, because it's different authorities that are each issuing a fine, sometimes in a different language, or more often than not in a different language, under different facts for international and national companies. Would you say it's the same thing under PIPL?
I would say the differences across different government agencies also, appear, have its place in China as well, because as I said, there were multiple government agencies, they apply the same law, or maybe different law. For example, the financial regulators, they also regulate like financial consumer data protection, but normally they do not cite the PIPL, but like banking laws or insurance laws. So under those laws, they have different like penalty mechanism. So I would say, due to the multi-agency approach, and also, the enforcement power sometimes rests with local agencies, even within the same authority. If they have, 31, because, we have 31 provinces, so which means that potentially we have 31 local agencies, they have their own kind of interpretation about how to enforce the law. So it's not unbelievable, and could almost be certain that there might be some, uncertainties or differences between across different agencies and different branches. So that's why actually I recall last year, the CAC introduced kind of like enforcement procedure rules, to bring more transparency, I think, to the general public and also to the local branches about, how to enforce law in a uniform way, and, to assess the penalties in a kind of more uniform way to provide more certainties to the business community. Yeah.
Thank you. We do have a question. So Annie, you mentioned, you were talking about the penalties they can apply to an individual.
Yeah.
So does PIPL specifically define who a directly responsible person is? Or is that also going to be subject to some kind of interpretation as to who is directly responsible?
Yeah, they can. I'm not sure whether it's asked by an American audience, because I'm quite aware that in the United States, it's somewhat different from the case in China and maybe in many other countries, including the EU, because here the DOJ or FTC or other agencies, they cannot directly impose fines to individuals or investigated companies. They somehow have to bring a sort of lawsuit to the court, and so it's the judicial procedure has to be applied. But in China, like the CAC or MIIT or the public security authorities, they can directly impose fines to companies and individuals within their authority scope.
So they determine who is directly responsible.
Yeah.
Okay.
It falls within their discretion.
Okay.
Yeah, of course they have to do the investigation.
So Noah and Sooji have been very patient and in the background here listening to all this. I want to bring them into the conversation now, because they're dealing with this on a day-to-day basis. So I know we talked about talking about the cross-border implications and getting into personal information, important data, PRC, state secrets, consents, and how all that's working in real life situations. So Sooji, do you want to kick that off?
Happy to. And firstly, thank you, Gary, and my esteemed panelists for the opportunity to hang out with you today. And for our participants, thank you. You had lots of choices for Friday, Easter Friday, so really want to thank you for hanging out with us as well. So as Annie and Sarah beautifully teed up, there are so many things a private sector or public sector need to go and figure out. What's most critical is prioritization. And one tip I have is always look at it from a intersection of business requirements in terms of business imperatives and then risk reduction, because we're all here to be of service, right? To the companies we work for, if you're in public sector, to be able to ensure that the infrastructure continues to work that it's meant to do. And so number one thing I would you'll get a hang of this. I speak in 3 bullet points, so I'm going to do it in 3 bullet points. Bullet point number 1, firstly, you really need to start with an aligned business strategy on data. When you boil this right down, whether it's personal data defined under GDPR or personal data and or important data defined under PIPL, you've got to have a data strategy. And that data strategy is not the people who have privacy in their title. It's much broader. You really need to have and level it up to that C-suite. And for some of you that are publicly listed, board level conversations. What is the data strategy? And don't forget, data strategy always involves what I would describe as the 3-legged stool: people, process, technology. And when you think about that data strategy from the people, process, technology lens, think about, do we need to have a model where it's self-sustainable? We hear about environmental sustainability. Think about it from a data sustainability. What's the strategy for data as an asset? Should it be a model of, for example, air-gapped 100%, where it's self-contained, right? Alternatively, do you need to consider something a little less dramatic, right? And consider maybe a full or partial data localization, which is complemented with identity and access management controls. Annie, I know you're going to nod to this, and it's limited to local team members so that some of your regulatory requirements, maybe slightly the burden, slightly lessened. And it also pulls that thread through, right, Sarah, with SHRMs 1, 2, and 3, and who knows how many more of these decisions we'll get. Secondly, I would consider the upstream impact. So when you talk about your data strategy that has a data lifecycle management, think about the upstream impact from a user perspective. And I'm not just talking about customers, employees. Think about your suppliers, your partners that you work with daily, because what you do is going to have a direct impact on them. For example, is it going to disrupt for employees, the wonderful employee benefits and the experience they have? Is it going to lessen that? If you're a customer, consider, am I going to continue be able to, my company going to continue be able to provide that high quality, responsive support, supply and services? Super important, because it shouldn't degrade. It should be better, right? As you go through this marination, if that's even a word. And then thirdly, double down on your company's commitment on transparency, trust, and information security. If you don't have those commitments explicitly stated on your website, now's the time to get your friends in marketing and who are very good at branding to tell a crisp story of what your company is today and where it continues to evolve and grow. And my last piece of advice is, don't forget, personal data governance is really, at the end of the day, tied to data governance as a whole. So look at your controls on data governance and make sure it's embedded in the business processes. We're not going to be able to change anything if we have our own little standalone process, because they will figure out, well, I'm going to go pull it from somewhere else, right? You've got to really be able to embed yourself as part of the business processes. They're my three sort of gold nuggets I would highlight to the audience. And I'm sure you guys have it all, but if you don't, hopefully those three would be useful.
Noah?
Sure. Gary, thanks for having me. And I do need to say, you know, I'm only speaking for myself today, not GE. But I believe I was invited just because I have a very sort of practical viewpoint of this, because in the last 6 to 8 months, GE has gone through this process, and we actually filed our security assessments, I believe, on the 28th of February. And we should receive feedback, we're hearing, sometime next week. So that gets to one of the points actually you had asked about. We were supposed to receive feedback in 5 days. Instead, it's in 5 weeks, because the CAC, not surprisingly, seems to have had a much greater volume than they originally expected. It might be worth just quickly going through sort of what our process was. And I'll start with a comment on fines, actually, because interestingly, I don't think we ever discussed fines. And the reason is the immediate threat is business disruption, right? You know, if you're engaged in particularly risky data practices, that's one thing. GE is wonderfully boring with respect to data. We're doing HR data, a bit of marketing, but and then we may have some important data. We're still waiting on the definitions. But that's not, data is not how we make business, at least, or excuse me, how we make money. That's at least in this respect. So our concern was, what do we have to do to ensure continuity of operations? We went through MLPS 3+ years ago. And actually, when this first came out, one of the first things we did was review our employee consent and tweak that to ensure it reflects the most recent guidance. Then, of course, there's the inventory of what applications and data we're using in China to determine what the scope of the issue was. At the same time, and I think this is important, we spent quite a bit of time selecting suppliers, both for what I'll call technical advice, although it's not really technical, but we selected a boutique firm in Shanghai that advises on PIPL, CSL, and DSL compliance. We also selected a law firm that we'd worked with many times, DLA Piper, for sort of broader legal advice. And they're not the same thing in this context, because a lot of what you're interpreting are very specific aspects of the PIPL. You know, it asks for a particular type of evidence. What evidence will satisfy that, and how do you balance the risk versus the reward of providing that? Because there are some things that were asked for that I suspect very few Western companies will provide, and we're going to see how that turns out when we get it. The advice
Kinds of
back.
examples of that, Noah, without giving us specifics.
Sure. Well, one thing that was asked for were contracts with suppliers, which are generally confidential. So you'd have to talk to the supplier, and also what parts of what contracts, right? when they get into specific controls, et cetera. We immediately actually provided our privacy and data protection attachment, which goes on all our supplier contracts, as well as the third-party security requirements. We were hoping that would satisfy the requirement. We'll see. We were advised it won't. Another is IP addresses for suppliers. That can open up a whole host of security issues. So again, that's going to be a big one I'll be looking for with the feedback. In any case, once we onboarded those suppliers, we had to decide whether to go with the security assessment or try to rely on the SCCs. And as far as I have heard, the certification route really isn't open yet because nobody's been designated as being able to certify. In our case, as most will have heard, GE is splitting up. So in fact, once healthcare left us on January 4th, right in the middle of this process, we were under the 10,000 threshold. And that's why I said we had to make a choice. However, there was also this question of whether or not we process important data, which is essentially national security data. We're in the business of supporting, building and supporting power plants, aviation engines, et cetera. So we were advised and we thought that the Chinese authorities would likely be very suspicious if we said we didn't have any important data. And so we felt it was better to go the security assessment route to ensure that we can continue to export PI. And by the way, with respect to PI, our assumption was that every employee record includes SPI, right? So a fairly simple way to calculate that is to look at the number of employees in China, consider those each to be an SPI record, and there you've got a number. In any case, so we did go the security assessment route. It was not easy. One of the first things we received was a spreadsheet listing 79 categories of evidence that we needed to provide to our supplier, and that would eventually make their way into the declaration. And we quite literally spent, 4 months interpreting that spreadsheet, providing the evidence, updating the evidence, and also a certain degree of remediation. The two biggest examples being that we used the draft SCC as a template for an intragroup agreement between GE China and sort of big GE. And at first we had asked, we're a BCR company and we have it for both processors and controllers. Will the BCR satisfy this requirement? And the response back was no. So
Noah, before you go on, just in
sorry.
case people in the audience aren't familiar with BCRs, can you just talk a little bit, just explain quickly what that is?
So binding, well, Sarah would be far better than I am, but it is a means of transfer in Europe. You have to go, it's an extensive assessment of a company's practices and a commitment to uphold those practices, which goes through one of the regulators in Europe, in our case, the French regulator. And after, I think it's a several-year process, it gets approved. That becomes your primary method for transfer. Sarah, do you want to comment?
I think you did a great job. Just to summarize for everybody here, if you're transferring data from the EU to a country that does not have the same level of protection, and the EU has deemed the US not to have the same level of protection, you have to use a means to do it. We used to have Privacy Shield, and or before that, also a safe harbor in order to transfer data, but those have been validated by Schrems 1 and Schrems 2. And now it's BCRs, which is binding corporate rules, and or SECs, standard contractual clauses. And so in order to put in place BCRs, a company goes, as Noah clearly stated, through a process with a local data protection authority in the EU, meaning on a national level, to get them approved. The process takes approximately 2 years, more or less, but it's a way for you to be able to transfer data from the European Union to the US. Now, here's an interesting bit of information. Schrems 2 happened July 16, 2020. I have been filing BCRs now for years, right? I had filed BCRs for one company in June 2020, and those BCRs today have not gone through because the data protection authority with which I filed the BCRs has refused to, as have other data protection authorities in the EU, approve any BCRs that contain data transfers between the EU and the US. So if you are filing BCRs right now and they include the US in the scope of your filing, you're probably not going to get them passed because they're just not getting passed by any of the national authorities. So BCRs are a tool, but the truth is right now, it's not a realistic one for the most part. And what you have to rely on the SECs if you don't already have BCRs in place. So standard contractual clauses are the ones, which is the tool that's available to us today, an imperfect tool, and we can discuss that for hours, how they are imperfect or not. But the BCRs today are not getting approved by the national authorities if the US is in the scope. Does that make sense?
Yeah, and the BCR, just to clarify, that allows the intra-company transfers.
Yes.
So if you transfer to a third party, you're going to need
Yes.
SECs for that. So Noah, I apologize for interrupting, but so GE has a BCR, but China doesn't recognize that then.
Correct. So we did an intragroup agreement based on the Chinese SEC. Because we knew that we were likely to have important data, the national security data, we also included important data into that agreement, anticipating that that would be wanted. That proved to be a mistake because since then we've been advised that we need to redo our intragroup agreement based on the SEC for the Chinese SEC for personal information and do a separate intragroup agreement covering important data, which, by the way, there is no template for. So we're working on that. The other sort of significant piece of legal work that we had to do, at least internal legal work, is a addendum to our classification standard. We have a strong global classification system, but it doesn't cover the China-specific requirements with respect to grading of data based on industries, et cetera. Our classification schema allows for supplemental labels. So using that, we produced, I guess you'd call it a working instruction or a work instruction on how to classify and grade data in China. So having done all of that, we put together our declaration. It ran into the hundreds of pages. It is with the regional CAC for Shanghai, and we are looking forward to their feedback shortly.
And all of this mostly based upon HR data.
In this case, yes. In fact, our first filing was entirely for our HR data. We haven't filed for important data yet because the standards aren't clear yet. But we were also advised, get something in by February 28th, which we did.
And Gary, if I may, I think what Noah described is pretty much a lot of companies' journey, right, Annie, in terms of how they've gone about it. Some companies had flipped the order and looked at consumer data first, right? Because the threshold for consumer data is very similar to what Noah just described from an employee lens. And consumer data, this is one gift from GDPR. If you did your data mapping well, and you did it for global applications, it then is triangulating that from a China lens and pulling out what is China for China only, separated, because you don't need to talk about that, right, Annie, It is purely just the cross-border implications. So my other tip for the folks on this call is take what you've done for China, for GDPR. If you've done a good job on data mapping, extrapolate that and pull that thread through, and then see the China connection. But don't stop, because this is not going to be one and done. It's going to be iterative, because you're going to see this in other emerging laws, other requirements. So that's where you go back to what's your data strategy, what's your data lifecycle management, and build that into your overarching data framework.
Well, and on that topic, we extended our record of processing to become a global system. We did a specific questionnaire for China, but so we're able to, for instance, use our our existing record of processing records for HR, so Workday, do the China questionnaire and use that to support these assessments.
Very smart play, Noah. Love your playbook.
Sooji, have you gone through a similar experience then?
We have. We started with consumer data first and looked at that. 3M is a manufacturing company predominantly. We do have direct access to consumers. Some of our divisions, we have a consumer division. We have a healthcare division where you've got direct access to consumers and patients as well. And so that's what we tackled first, because that is my understanding what the CAC is most keen to learn about. Employee data is important, but we heard through the grapevine, it's not the number one priority. It's in there, but it's not the one. And similar to Noah, our journey was very much, let's do three things. One, map the data and data flows, understand the criticality in terms of the data classification. We already have that in place at 3M, but then determine, number two, the business processes that feed into it. So the records of processing, which is the GDPR, what's the delta, is then the gap assessment. And then the third thing is look at your security controls to determine, does it map up, roll up to the various local legal requirements. And when you sort of think of that as your 1, 2, 3 step, it becomes a little easier in then defining what do you go tackle and how do you prioritize what you need to go do.
Thank you. Thank you.
Well, and I should have commented that fortunately for us, since selling off lighting and appliances, GE is a B2B company, so we deal with very little consumer data.
You are so lucky, my friend. You are very lucky on that one. Take that win.
Very aware.
So Annie, I mean, we're talking with representatives from two very large and I'm sure well-staffed companies. Although I'm sure each of you would like to have more staff if you're like any other company.
I would say reasonably staffed, and some of my team members are on this call and they'll probably ping me if I said something else.
Yeah.
So Gary, actually the team that did this was 3 people.
Wow.
At times 4, myself for the legal side, a representative from our digital technology activity in China, another in Russia, and then we had some contractor support in China. But we also have GE tends to run a very lean privacy staff. We only have 3 people in the privacy office at corporate. We do have privacy people down in the business units. And that's a whole nother layer of this. The HR processing is done at the corporate level. So that's why we filed, going forward, particularly as GE separates into 3 companies. And by the way, try layering on a separation to a new filing like this, and it redefines fun.
No, I have absolute confidence. If you can do CAC as a divestiture, you can do it in sleepwalking.
We shall see. So in any case, you know, down the road, the business units will actually have to decide whether they want to continue to rely on the security assessment, move to the SCCs, et cetera. But it's very much an ongoing process that will require staff at some point.
So you had a team of 3 people heading this up, but
Correct.
I imagine you had to work with a number of other departments to do this.
Oh, constantly. I mean, that the 3 people were sort of the management level. We got a great deal of support, particularly from IT.
Okay. And I know Sooji, when we talked before the webinar, you had made some comments specifically on this point, and you differentiated, I think, security from third-party risk management or privacy.
Yes.
Can you, yeah.
So super important, guys, when you sort of think of, and I'm going to start with sort of vendor risk management, Gary, and how do you, when you think of your suppliers, your service providers, your partners who have access to it, how do you build and weave in that muscle memory of the controls that you said and committed to in your CAC, right? Submission, that is that continued evolution of it. So don't forget your third-party ecosystem. And if your gate in is the IT security risk assessment, right? Don't lose the opportunity to anchor in the important data lens in terms of the review and the personal data risk assessment, right? Because you've got the ability to layer that there rather than create something that's standalone and doesn't merge.
Okay.
Actually, Gary, I have a question for Annie on this with respect to third party, because there are sort of 2 interpretations of how data is being exported from China. One is that you've essentially just got one set of parties, the Chinese entity, in our case, GE China, and the US GE, and then any onward transfer is occurring inside the United States. The other view would be that you've got GE China, and then any third party, such as HR processor, et cetera, in the United States. And the difference being what you have to file in your security assessment. And I'm just curious, Annie, if there's any consensus on which view is correct.
Just to clarify your question, so you're saying that whether you do the internal kind of intra-group data transfer and transfer to the, you know, your how to say, related or connected companies within the same group, what's the difference between that and with the external third party?
Yes.
Right? Yeah. Sorry, go ahead.
Well, I mean, how can I put this? So if the third parties are contracted for in the United States, I'll use, I guess, Workday as an example for us. They're our primary IT provider. They're contracted for in the United States. The data goes from China either to, and I don't know the technical details, but it either goes from GE China to GE US and then to Workday, or I suspect it's possible in many cases with third parties that even though the contracting process occurred in the United States, data may actually flow directly from China to a third party.
Yeah.
What we heard was that most companies were viewing this as only occurring between GE China and GE US. So only an intra-group agreement was required as opposed to all of the contracts with all of the third parties. And soon that will mean SCCs with the third parties. And I've also sort of heard that some of the third parties are taking the view that the transfer is within the company, so they shouldn't have to sign SCCs.
Yeah, I think I would say that, you know, the contract should be signed between the data exporter and the data importer. So as long as it's like GEUS is a direct receiver or data importer on the US side, I think the agreement should be signed between GE China and GE US. But definitely you have to factor in, the third party, like probably HR vendors or maybe Workday providers. You have to factor in this kind of situation within your ICC, to make it very clear, after GE US receive the data from China, what the onward transfer is going to look like and how you ensure the onward transfer is safe and provide the equivalent level of data protection as in the case in China. Yeah, that's my understanding.
Thank you.
Thanks, Annie. We have, I have another question for you, Annie, but we have a question from the audience about how the Chinese authorities look at SaaS platforms hosted and operated outside of China who have clients, users within China.
Yeah. Okay. So I think first of all, because they specifically, just as in the case of the GDPR, Chinese PIPL has a long arm jurisdiction, extraterritorial jurisdiction. So even if the SaaS, service providers, they're located outside of mainland China, but they specifically target the Chinese market. So when it comes to personal information and important data, the overseas SaaS service provider will be subject to the Chinese laws, which means that they will have to do all the compliance measures. No matter it's a cross-border data transfer or consenting or any other kind of regulatory requirements, they have to satisfy them.
So Annie, Sarah, I mean, I going back to what I was saying earlier about we're talking to two large companies, although NOAA has been able to do this with a very small team. But I would imagine smaller companies who are doing business in China, they're going to be very resource challenged. So what are your recommendations to clients who are doing business in China, want to stay in China, but need to work their way through this process?
Yeah, so probably I go first. And maybe Sarah can add on, because I think Sarah probably has more knowledge about how the small and medium-sized companies, do the very hefty GDPR compliance. I think the SMEs can learn a lot from these experiences when they do compliance with PIPL in China. So I think first of all, unlike the GDPR, which has some exemptions of compliance work when it comes to small and medium-sized enterprise. For example, the smaller companies with less than 250 employees, they can be exempted from certain keeping the records, documentation. but unfortunately in China, we do not have this kind of exemptions. So it's true that for the SMEs, they have very kind of hefty compliance workload. So I would say that, first of all, you have to make sure that no data breach. So as long as no data breach, even though you are find that, you are not 100% compliant, but the worst case is that you might be given an instruction from the authority saying that, hey, you're not doing well, you need to do some remediation, corrective measures, but not direct penalties will be imposed on to the companies. That's one thing. You have to make sure that no data breach. And the second of all, I think yes, I know it's a long journey and probably it never ends. And everyone, even the authorities, they are aware that, Rome is not built in one day, right? So you have to, embark on the journey of PIPL compliance somewhere. For example, I would say like they privacy policy or privacy notices would be a good starting point, because normally it will have kind of more public exposure because it's posted online or it's directed to the employees internally. And the authorities nowadays, they do the kind of online scouting. They can very easily check your website and see whether you have a privacy policy and whether it's drafted in a way in line with the PIPL and implementing rules requirements. So probably you can start from the easy ones, and also those ones could be the biggest risk exposure, because it's very easy to find, you are not complying with the PIPL. But underlying the privacy policy and privacy notice actually are your like data protection and security measures. You cannot just put all the commitment in the paper, but inside your organization, actually you're not doing anything solid, right? So, but you can do it, build up your compliance programs, gradually, do like the gap analysis, maturity assessment, and the remediation in phases. So I would say that could be a pragmatic way for the small and medium-sized companies to achieve, PIPL compliance. Yeah.
So when it comes to GDPR compliance, I actually think that the distinction of small and medium companies is sort of an artificial one. I think the real question is, are you a data heavy company? Are you a PI data heavy company or not? And that's the real question, because let's say you are not a personal, information PI heavy data company. I think that for the most part, you're not handling a lot of personal data. There's not a lot of international transfer going on. I think for the most part, you can split the responsibilities between your HR department and your IT department, because nowadays your HR, and I say HR because those are the ones who are handling employee information, and your IT department, those guys have now training, or at least some training as to GDPR, some training as to how to handle personal information. So you are not a data heavy company. You can kind of push in those departments at least to put in place some rules and regulations and some policies, and to help at least in some contractual stuff. It might not be perfect, but you can really push on those two departments. Now, let's say you are a data heavy company, you're a small company or a medium company. I hate to say this, but you do have to invest in some business partner or trusted advisor. It might not need to be a lawyer, but there has to be a relationship with somebody that can at least help guide you as to what you should try to have in place, so that you're not Googling online, so that you're not getting advice, from the internet. And there's even in a law firm like Winston, clients come to us all the time and they say, well, look, we don't have a huge budget for this. What can we do? And we have, a checklist in place that we give to some of our clients with like, okay, so these are the things you should look at. This is not legal advice, but be aware that you should put in place these kinds of things. And then clients come back to us and they say, okay, we see that this is a lot. This is our budget. What can we do? How can we at least try to get some of the compliance there so that we are not in trouble? And it's not a perfect process, but no matter what you do, and Sooji will probably agree, there's always a level of risk. Okay, it's up to the general counsel, it's up to your HR department, it's up to your IT, IP, it's up to, in combination with your lawyers to decide where does the risk fall. Is it low risk, medium risk, high risk? How risky is my activity today? So if you're a smaller company, not too data heavy, you can kind of rely on the assets that you currently have in the company to help you along, okay? If you're a company that's a data heavy company, you have to invest to some extent into GDPR compliance, because you are at risk. I mean, if you're handling a lot of personal data, you're handling a lot of sensitive, I say in quotation sensitive, because obviously it's a special category of data. You've got to try to find a business partner, a business advisor, a trusted advisor that can help you in that process and set up a realistic budget for it. Again, an assessment of risk. Everything is an assessment of risk. Nothing is perfect, but that's the advice that I have for companies that are data heavy versus not data heavy.
Yeah, and
Thank you.
Sarah, I think you just are spot on in that very pragmatic advice. I actually think it's a little easier when you're a smaller company. Yes, you may not have the resources potentially or access to resources that maybe a larger company may have, but you're actually a more agile in knowing where your systems are, knowing what's connected, because your IT team is pretty nimble, right? They know what their environment is because they've set it up, and they know how the digital assets and the IT assets flow. That is where I would start. IT and cybersecurity team know what assets are critical and key because they've gone and done the tiering on it. Start from there, guys. Don't try and create something net new. Use what you have already within your client set, and then learn to understand the relevancy of the what, and then weave in what you need so you can work on it together.
Right, great advice. We have a couple more questions that I want to get to because we only have a few more minutes. Following up on the GE example, when GE imports personal data and then uses a third party to process it, are you getting consent from the data subject for Workday to process it? And is Workday willing to sign a data handling agreement taking on PIPL obligations as a matter of contract? I know I worked with Workday on GDPR stuff, and we did get them to sign a GDPR addendums. But have you, Noah, Sooji, have you had issues in passing down obligations to your vendors?
Noah, why don't you go first, my friend?
Well, I can't speak to specific relationships, but I do think it's an open question as to what these third-party suppliers are going to be willing to agree to down the line. That's why I asked whether there's an interpretation from the regulators. Now that said, as I mentioned earlier, one of the first things we did was go back through our employee consents in China and revise those, not a lot, but to make sure they aligned with the current requirements.
Okay.
Yeah, Sooji, anything to add?
Yeah, I would, guys, look at this as an opportunity, and it sort of goes back to your whole third-party risk management program. When you think of a vendor assurance program, it will require due diligence pre-onboarding. It will require, number two, reflecting each party's obligations, memorializing it in a written contract. I would try and elevate it and create some sort of global data processing agreement that sets out your privacy and security expectations for both companies. Because when you think about the breadth and the depth of laws you're seeing, I don't have infinite resources, and a couple of my team members are on it, so they're going to be pleased I'm saying this and it's being recorded. We got to do it so it's agile. And so you pick your highest standard, and you're going to start finding some of your vendors are not going to comply. So guess what? You'll need to have a business continuity and disruption to transition them out, so that the ones that do remain can comply. That's where I would be going, Gary, and folks, whoever asked that question. Have a vendor assurance program that's scalable, and your contracts can withstand a lot of the country nuances. Because when you think about it, all of the principles we're talking about are embedded in the OECD principles. We're not doing anything different. It's those principles that are then cascaded in the country laws.
Yeah, I should say we have a privacy and data protection attachment, which is exactly what was just described, as well as third-party security requirements. We were advised that the CAC would not accept those. Our long-term plan is, even though we're relying on the security assessment, we're going to get the Chinese SEC signed much in the same way that we got the new European SCCs signed. It may take a while just because of the contracting cycles, et cetera, but that seems to be the safest approach.
Thank you. Well, I knew this was going to go fast. And I think we probably could be speaking about this for the next couple of hours, but it is a Friday. And I appreciate all the people who attended. We will be posting this video at some time up on the center's YouTube channel for people who've missed it. I want to thank the panelists. You guys have just been phenomenal. Sara, Annie, you and I have been talking about this for months, about getting a webinar like this together. So I'm glad we finally did it. Sooji, Noah, thank you so much. I want to thank Carolyn Big for the introductions to you. Carolyn is with DLA in Hong Kong. I want to thank our sponsors again, McAndrews and Leydig. And I wish everybody a great holiday weekend if you celebrate, or otherwise just a great restful weekend. The sun is out in Chicago, so that's good. It's not snowing. We'll take that all day long.
Thank you so much, Gary, for being a brilliant moderator, and to my panelists. So cool to hang out with you today. And happy holidays, everybody. Cheers. Bye.
Thanks everyone,
Thank you.
by the way.
Thank you very much.
Thank you.
Bye.
Bye-bye.